Hello friends. One of the main objectives of any law is to protect the rights of its subjects, but when the law is prone to get misused or has vague and ambiguous provisions, it becomes a tool to harm the citizens instead of protecting them. In the course of curbing one evil, greater evils are born due to such laws. The Unlawful Activities Prevention Act 1967 is an example of such a law. Initially, UAPA allowed the government to designate any organization as unlawful, but with every amendment it was made more draconian, particularly after the Prevention of Terrorism Act 2002 (POTA) was repealed. POTA was one of the most ruthless laws India has ever seen, which inherited many of its provisions from the repealed Terrorism and Disruptive Activities Prevention Act (TADA). Therefore, the provisions which were in TADA and POTA were included in UAPA by amendments in 2004, 2008 and 2013. Bail was made an exception instead of the norm. Definitions were left vague. Provisions that gave unlimited powers to the agencies were included, and the overall procedure of the trial was made rigorous. All principles of natural justice like bail is the rule, presumption of innocence, right to be heard, everything is thrown to air. This ruthlessness reached a height when the recent amendment of 2019 made it possible for the union government to declare even individuals as terrorists too without following any formal judicial process. Today in this video, let us look at how this law is being misused and what are the provisions of this law. I am Nihal Mohammed and you're watching The Upfront. The People's Union of Civil Liberties, on the basis of data from the National Crime Record Bureau, reported that only less than 3% of the arrests made under the UAPA between 2015 and 2020 have resulted in convictions. Out of 8,371 persons arrested under the stringent law, only 235 were convicted in the last 5 years. Because of its inhuman trial procedure, many innocent people have to spend years in jail until the court acquits them for no evidence. In July 2021, a court in Chhattisgarh acquitted 121 tribals booked under this law for allegedly assisting Maoists in the 2017 Burkapal attack, but no evidence was found against them. Similarly, Muhammad Ilyas and Muhammad Irfan were wrongly charged under UAPA in 2012 and were punished for an offence they never committed. Though a court acquitted them in 2021, the 9 years they spent in Mumbai jail could never be compensated. In another case, a local court in Gujarat's Surat city acquitted 122 persons after 20 years who were arrested under UAPA for participating in a meeting organized by the banned outfit Students Islamic Movement of India. There are hundreds of similar cases where people charged under UAPA were found innocent, but the cruel system does not make authorities accountable for the wrong they have been committing for decades under the cover of such laws. With an already extremely cruel record now, the recent judgment of the Supreme Court while dealing with a review petition in the case of Arup Bayan versus the state of Assam, upholding Section 10 Clause A, Clause 1 of UAPA will only increase the risk of the abuse of power. As per Section 10 Clause A, Clause 1 of the Act, a person who is and continues to be a member of an association declared unlawful by a notification issued under Section 3, which has become effective under Section 3 Clause 3 of this Act, shall be punishable with imprisonment for a term which may extend to 2 years and shall also be liable to fine. This provision, which is prone to misuse, was read down by the Supreme Court in the case of State of Kerala versus Ranif in 2011, in which Dr. Ranif was persecuted under UAPA merely because he treated one of the assailants who got injured while attacking a professor of Newman College. In this case, the Supreme Court, while hearing a bail appeal, relied upon judgments, namely Scales versus United States, in which Mr. Justice Harlan distinguished active, knowing membership and passive, mere nominal membership in an unlawful organization. The Supreme Court further mentioned similar observations from the cases Elfrant versus Russell and Joint Anti-Fascist Refugee Committee versus McGrath. This case of Dr. Ranif, which strongly opposed the concept of punishing people under UAPA solely based on membership in an unlawful association, became the guideline for the High Courts and Supreme Courts to follow in similar cases. Union of India approached the Supreme Court to seek a reference for a larger bench. When the Supreme Court in Uapa vs. State of Assam following Ranif case relied upon the same American doctrines and observed in paragraph 12 as under. In our opinion, section 3 clause 5 cannot be read literally, otherwise it violates article 19 and 21 of the Constitution. It has to be read in light of our observations made above. Hence, mere membership in a banned organization will not make a person criminal unless he resorts to violence or incites people to violence or creates public disorder by violence or incitement to violence. Hence, the conviction of the appellant under section 3 clause 5 of the TADA is also not sustainable. In its decision, the Supreme Court restricted the scope of section 3 clause 5 of TADA, which is para materia, to the section 10 clause A clause 1 of UAPA. The above mentioned judgment was challenged by the central government on the basis that relying on a foreign court while reading down a provision of UAPA is unreasonable, particularly when the Union of India was not a party to the case and impugned section 10 clause A clause 1 was not even in question. Thereafter, the three-judge bench, after hearing the arguments, upheld the constitutionality of section 10 clause A clause 1 of UAPA and overruled its previous three judgments: State of Kerala vs. Ranip, Uapa vs. State of Assam, and Indradas vs. State of Assam, on the ground that this court in the case of Uapa and Ranif has erred in a straight way and directly following the US Supreme Court decisions, and that too without considering the differences and the position of laws in India. The Supreme Court didn't find the impugned section vague and thus observed that the mere possibility of misuse cannot be a ground or relevant consideration while checking the constitutionality. The fact which was not considered here is the data of the Union government and the PUCL report, which clearly suggests that UAPA has not merely a possibility of misuse but rather is already being misused at large. Particularly after the last amendment, there is a sharp rise in the incarceration of several prominent human rights defenders, journalists, civil society leaders, and even protesting students from different universities. Besides sedition, UAPA was used against agitating leaders during anti-CAA protests. It is ironic that a law that was apparently designed for the protection of citizens from unlawful activities is now being used as a tool to suppress their dissent. It is pertinent to mention that this lengthy judgment of 145 pages did not address the ambiguity of the terms within the Act, which makes it more draconian. Moreover, while diminishing the difference between passive and active membership, it has not even mentioned what makes a person a member of such an association and on what ground it is to decide about who is and continues to be a member of such associations. Leaving these questions open to interpretation and reverting to the guilt of association doctrine, the Supreme Court has further sharpened the cruel tool to further incarcerate people without any checks and accountability. That's it for today. If you like the content we provide, please subscribe to the Upfront and press the bell icon to get notification of all our updates. Please share our videos and educate others. Thank you.